Happy Tuesday, everyone. Our very last Happy Tuesday of 2020. Before I get started on our mortgage moment, I just want to take a minute just to say thank you to each and every one of you who have utilized Prosperity Lending for your services this year. We have helped over 300 families this year, whether it's for refinancing and purchasing, and those were a direct result from you, not only your clients, but you personally. So thank you to each and every one of you. As we move into 2021, I want to make sure that you're taking advantage of us based on the marketing efforts and branding and co-branding opportunities that we have together. Want to share some of the tools and resources that we have. And if you're not working with us today, please make sure you reach out to one of our Prosperity Lending loan officers. I will also be providing our roster, so you have the information as to the loan officers who are on our team, and you'll have all of their contact information. But the resources that I want to point out are going to be our Blend app, which is something that you can actually download today. All you have to look for is Blend, whether it's on your iPhone or on your Android. Look for, download the Realtor version of it and look for one of your Prosperity Lending loan officers on there. All you have to do is submit to your clients the client's name and phone number. The information actually goes to them as well as to us, and we all have the information once they actually download the app, and we can watch them walk through the app all the way through completion. Great way to keep track of our leads and applications, and as well, once they're in contract, you'll be able to get the updates as far as in processing, underwriting, and of course, our most favorite part is funding. The other thing I want to share with you is list reports. We talk a lot about list reports. I think last week I shared my top 3 reasons why I love it. There are some new things to list reports. So if you haven't dove into that or don't have access to that, please make sure you reach out to one of us. The other thing would be MBS Highway. So with MBS Highway, there are some great realtor tools on there. One of my most favorite is our buyer purchasing power flyer, as well as the buy versus rent detail. So if you have any questions on what that is, how we can get a widget onto your website, again, feel free to reach out to one of our Prosperity Lending loan officers. The final thing that I want to throw out there is HomeBot. A lot of us talk about how can we continue to stay in front of our clients? How can we stay top of mind? This is a great tool for a minimal cost. I think it's like $25 for our agents. It'll allow you to stay in front of your clients every single month, primarily if they're an owner of a home or multiple homes today, provides them with evaluation, gives them some ideas as to what the market looks like with respect to interest rates. Also, for your buyers, it allows them an opportunity to search in specific zip codes, and you have an opportunity to see when they're actually online looking and previewing the information. And your information is also in there. So if they have a question, it's easy for them to just click on a button and send you an email directly to your email and to us if they have questions about refinancing or about interest rates. So if you haven't already met with a Prosperity Lending loan officer for your 2021 goals and your business planning, please reach out to one of us today. We'd be happy to help you grow your business. And again, thank you so much for an amazing 2020, and we look forward to 2021. Back to you, Vandana.
Thanks so much for tossing it over to us, Shelley. We appreciate you, and we are so thankful for your partnership in 2020, and we look forward to an amazing 2021 with you. Today, we are going to have our legal update with Attorney David Sanders. We've got you, just so you know, listed as legal attorney. You're actually legal counsel. But hey,
I'm okay with both. The bar license says both. We're good.
Perfect. That'll work for me too. So, we've had so many things happen this year, especially with COVID coming around and being in quarantine for a good majority of the year, me more than anyone else, I think. But either way, we've still had a lot of issues within real estate. And so I think it might be a really good idea to start off our legal update with things that have happened in 2020, sort of a look back of issues that have been of concern in 2020 and things that agents should look out for moving forward in 2021, if that's okay with you.
Yeah, that sounds fine.
Okay, so let's go into, I think your first topic for your look back into 2020 was put it in writing. And just so we're clear, I actually did do a broker insight on this about putting everything in writing, but I want you to really talk about the importance of doing that.
This is one of those things that every year is always going to be in the top 5 because, particularly this year, before when COVID first struck and we didn't have the forms from the association or from Signature, there was a lot of issues as to what you could do and you can't do. There's also the scenario where you have a client who remembers the transaction very different from you. And you need to put everything in writing. And I'm not just talking about, addendums or changes to the contract, which we all know it needs to be in writing. You need to be putting things in writing where, your client is telling you to, accept an offer at X amount of dollars or nothing less than that, because you want to start building that paper trail as it happens, because the statute of limitations for a real estate related case is going to be at least potentially 2, 3, maybe even 5 years. The way the courts are set up is we haven't had a jury trial since COVID, which means we have a massive backlog, which means civil cases are not going to probably go to trial for 4 to 5 to 6 years. And you will not be able to tell me where you were on December 28th or December 29th in 2020 in 5 to 6 years. Least of which,
I can't tell you what I was doing yesterday.
Yeah. None of us want to remember what happened this year. So do yourself a favor and write it down as it goes. So if you get the phone call from the client who says, we want to counter back with this, or these are the repairs we want to do, make sure you're putting that in writing. Make sure you're memorializing that in an email rather than a text message, because when you come to me in 2 or 3 years and you don't remember, we don't want it to be a he said, she said argument. We also, the way the division is looking at it, division cases that were heard last month or earlier this month in their hearings were from 2017, 18, and maybe the beginning of 19. So you're looking at 1 to 2 years where you're going to have to defend yourself. The GLVR is, I think, or LVR, I think they're getting closer, but they have a backlog as well. And it's going to take time. It's going to take probably the first 6 to 9 months, maybe even a year of 2021 before the realtors are caught up. In the division, they're always 2 or 3 years behind. And so, if you have that client that you think is going to maybe go sideways, or you have the other agent that's acting a little bit unprofessional, write those things down in the email that you have, save it to your system. I mean, we saw realtors getting hit at the division, which we'll talk about in a little bit later, by failing to produce their entire file, looking at a potential $5,000 fine each occurrence. So do yourself a favor, put it in writing contemporaneously right now when it's happening. So you've got that paperwork so that in 6 months or a year, when the other side or the buyer or your client comes back and tries to push back, you've got the paperwork to explain to them what exactly happened. I know we hit on this every year, but it will save you a whole lot of heartbreak and a whole lot of concern about the division and getting sued and everything else if you've got a great paper trail, because that makes my life, if I'm defending you as your lawyer, a lot easier, because I don't have to hope the jury likes you more than the other guy, or that the commissioners like you more than the other. And if you've ever heard a commission hearing in the last few years, I can tell you exactly which way the commissioners are going to go. There's a couple of them that are, your behavior is a complete disgrace to our industry. There's a couple of them that will say, I wish I would give you more sanction, but we're going to listen to the Attorney General. It puts you in a far better place, because if you're facing a sanction before the division, the AG's office calls me as your lawyer. We negotiate that settlement. And if I've got more leverage to say, here's your problems in your case, here's the paperwork that I can back that up, it's going to make your life and my life a lot easier. So do it in the moment. Make sure that you've got paperwork. And it's also part of your job under NRS 645 and NAC 645. And I know that Signature requires you guys to do it. So do yourself a favor. Get in the habit. If you get a call from a client, type up a confirming email. Make sure you include a line something like, if this memorialization differs from what you remember, or if this is not what you remember, please let me know, so that we have a defense built in if they try to claim that that's not what happened. Don't rely on text messages alone. Phones go away, you update, text messages disappear. Confirm anything that's going to impact your client's interests or potentially put you in front of the division or the real estate division. Confirm that in an email. You don't have to send it certified mail. You don't have to send it carrier pigeon. An email is more than enough.
So one of the things that I want to also clear up is that we talk about this a lot. We talk about it in our sales meetings. I know Janet has said many times, he who has the most notes, I can't remember what they actually win, but wins, I think. And then ultimately our files, we use SkySlope. And so our files through SkySlope allow us to upload our communication logs. So you can text message, take all your text messages and actually screenshot them and put them right into the file so that they're always there, because that we have to keep for a minimum of 5 years, right?
Make sure that if you are keeping a communication log, make sure you upload it to SkySlope. I have another client that is not related to signature that is getting multiple subpoenas because an agent made an offhand comment to one of the principals in the transaction that they kept a message/call log, and we got a subpoena asking for those call logs for like 7 years. And we have to produce that. Do yourself a favor as a part of your transaction. If you do keep a call log like that, upload it into your SkySlope system. Make sure it's there, because then when you get panicked because you get served with a subpoena and you call me, all I have to do is reach out to your office manager support team. They download the SkySlope paperwork. I review it to make sure there's nothing that's covered by privilege, and we turn it over, and it's the end of the day. It doesn't have to be anything major or unusual. You're gonna potentially get subpoenaed in civil cases. It's part of the game. As long as you have a full paper file, that's important. There was, again, one guy in front of the division who got dinged because he didn't, when the division asked for his file, he didn't include all of the paperwork. He eventually produced it all, but because of the delay, the division came after him and said that he was attempting to disrupt or manipulate a division complaint and brought extra charges of action for that. So do yourself a favor and just produce the whole thing prior to close, prior to your commission check, and then you don't have to worry if you haven't produced everything in 1 to 2 to 3 years. 30 to 40 to 50 transactions down the road where you don't even remember which one this is. It's better to do it in the moment.
All right, cool. I think we've beat that to death. If nobody understands what putting in writing means, please contact one of the brokers and we'll be happy to help you. All right, next topic, top 5 things. This is number 2, mediation. Our mediation process at LVR has gotten a little bit more complicated. It's not as easy as it used to be. So go for it.
So the mediation provision is I still think is something that you want to, if a client, of course, has a question that's a legal issue, refer them to an attorney. I don't think that it's to the point where you don't recommend that your clients execute it. I will tell you that the mediation process has got extremely more difficult during COVID. First of all, LVR isn't offering the traditional mediation that they did for years and years and years. They're just not doing that anymore. So your really only option, unless you want to pay a mediator, out of pocket. And so if your earnest money deposit is anything less than 15 to 20 grand, economically, it just doesn't sketch out. You're looking at the Regional Justice Center. And the Regional Justice Center does mediations for the public. If you go to small claims court or mediation or eviction hearings down at the courthouse, they're going to show up and say, do you want to mediate? My experiences with them have not exactly been beneficial. They've never asked for a brief. They've never asked for paperwork to justify why you think we're entitled to funds, particularly with COVID-related issues. That's going to be an issue. They don't want to see it. You're going to get a 2-hour phone call where they're not really aggressive in their mediation process. It's not necessarily a bad thing, but if you're looking for someone to convince the other side, the seller, that they need to release the earnest money, or the buyer to release the earnest money, that is not what you're going to get. And so you're going to spend a lot of time and maybe even be disappointed. So what I'm recommending to people right now is, if you want to execute the mediation provision, you need to be aware of these things. And then also, small claims is kind of open right now, but the court has been on their own bumping trial dates out to the end of 2021 because of the increased concerns with COVID. So I would tell you that if you have an earnest money dispute, it is in everyone's best interest to try to resolve it short of going to mediation, because the mediation system is not as helpful as it once was. There's not a whole lot of guarantee. Plus, the mediation center is the group that is going to be handling the eviction mediations. So I don't know how much capacity they're going to have going forward, just because, eventually in March, when the eviction moratorium ends and the eviction, I'm being positive. At some point it's going to end and the mediations are going to kick in. And the longer that eviction moratorium lasts, the more mediations are going to be out there, which just means it's going to be harder and harder to find somebody. So I think you need to be real, you need to be aware as a real estate professional that it's not the way it was at the end of 2019, where you had multiple options for mediation. You're able to get in on a really quick way and get a resolution. It's not going to be that easy.
But I want to clarify too, because the last time we had a legal update with you, we made it very clear that actually participating in the mediation, meaning, going beyond that one try of, yep. And so mediation isn't just for earnest deposits. It could be for repairs. It could be final walkthrough repairs, things like that. And we talked about how it's not really in the scope of your license to essentially act as an attorney to mediate this decision between the buyer and seller, right? Once the transaction's over, your job is over and you need to move on. And so not to continue trying to battle and go back and forth with the other side to mediate earnest money release or deposits. And quite honestly, the sooner you can get your brokers involved, the better off you're going to be, because we'll be able to help you get through that and potentially, recommend the next step for your client without you getting in trouble.
Correct. I know that you as realtors want me to tell you, you can do X and you can do Y. And the answer is, unfortunately, the way the state law is written, it says that the definition of practicing on law in the state of Nevada without a license is advising any individual on any issue that impacts any legal right. So essentially, everyone is practicing law without a license every single day. And they did that on purpose. It's not a bright, shiny line. It's going to be a factual scenario. So it is vital that you get your brokers involved as quickly as possible, because as much as you hate me saying it depends, earnest money disputes, when the real estate licensee's obligations end and the legal obligations begin, is going to depend on the facts of every single case. So if you think you're going to have an earnest money dispute, I would tell you, even before the deal completely unravels, get a hold of your broker, find out what we can do to start taking the proactive steps to not only protect your client, but to protect you.
Perfect. Okay, moving on. Number 3 of the top 5 things that have happened: broker agreements.
Correct.
Sorry, did I steal your thunder?
No. You didn't steal my thunder. So we're going to talk about the Department of Justice antitrust issues with NAR and the impact on your business soon. The reason why I like the buyer brokerage agreement is because it's specifically designed to protect you in that scenario when you're working with a buyer. It's got language to protect you from RESPA violations. It's got language to protect you from a variety of things that are contractual in nature. And as we're going to talk about later tonight or today, the amount of your commission amount is going to drastically potentially change due to this antitrust issue. The buyer brokerage agreement, at the end of the day, is the really only way that a buyer's agent can be absolutely sure they're going to be compensated for the amount that they are entitled to based on whatever number that is. The certain industry standards and practices that have been going on for decades in 2021 will no longer be there. So if anything, in the last 3 or 4 months, getting used to using the buyer brokerage agreement, being aware of the power that it gives you as a buyer's agent with your clients is going to help you pivot and transition to arguably one of the biggest transitions in real estate that's going to occur in 2021. So get used to using it now.
And if you need help with the buyer broker agreement, you guys talk to one of the brokers. We'll role play with you. We'll help you get through that process so it's easier to talk to clients about it. But ultimately, I mean, from what I'm hearing, what David's saying is that this is the only way to protect your income. And so unless you plan on working for free in 2021, start learning how to have buyers do buyer presentations with them and have them sign that buyer broker agreement. So at least you're covered. And here's the other thing, Dave. I mean, those buyer broker agreements, I can't tell you how many times I'll have questions about procuring cause issues that are arbitration related, right? And so my first question is, do you have a buyer broker agreement? And if you don't, it's really hard for me. I mean, yeah, I could fight it, but it's going to be a lot harder to fight if you don't have that buyer broker agreement in place. And so you just need to get in the process of presenting that to your clients and having them sign it up front. So
Yeah,
all good stuff.
Make sure that they sign it at the very beginning of your relationship. I know I probably shared this story before, but there was an arbitration case that both of the agents claimed procuring cause, and it literally came down to when in the transaction did each broker get that buyer brokerage agreement signed. Broker A had been working with the client longer, but broker B met with them and got them to sign the buyer brokerage agreement. And then broker A had it signed when they submitted the offer. And that's pretty much the reason why the panel went with broker B, because their buyer brokerage agreement had been in place the longest.
Nice. So ultimately, duties owed first, buyer broker agreement, and then go look at property. Nothing beyond, nothing in differing order, right?
Yeah. I would tell you, it can't be before the duties owed, unfortunately. So.
Right. Okay, next, Article 10. Let's talk about the changes to that article.
Okay, so Article 10 is the fair housing language. And it's a very interesting story of how this came to be. There's a realtor out of Atlanta who was on his realtor branded Facebook site, was engaging in what was called harassing or hate speech. And the local realtor board couldn't do anything because it's not a violation of Article 10 because it didn't arise out of a real estate transaction. Most people don't know that primarily most of the articles under the Code of Ethics have to be tied to a real estate transaction. Article 1, Article 2, on those things. And so what had happened is because there had been such an increase in hate speech, in harassing speech on social media, that NAR went out and changed Article 10. And now it is a violation of Article 10 for any realtor to participate in any kind of hate speech, harass speech, slurs against any member of any protected class, real estate transaction or not. So if you're on social media and you are engaging in that type of speech, and I'll be honest, I don't think anyone at Signature would, but this is a significant change because it's any type of speech. So if you're involved in a Facebook post or an Instagram post or a TikTok video or whatever it is, or a Twitter feed, whatever, but there's hate speech, it's a potential violation of Article 10, and you can get brought up on charges, and the fines are significant on this one. This is not a scenario where, and Vonda, you know this as being a former chair of professional standards, LVR's Pro Standards really likes to give you between 6 and 15 hours of CE. They don't really like to fine you. If you violate this provision of Article 10, it's a several $1,000s fine initially. It dramatically increases after that. There's no opportunity for education, which also triggers the fact that they can publish this if they think it's bad enough in the Southern Nevada Realtor magazine. And another fun part about this one is if they feel the hate speech is bad enough, they will refer you to the real estate division for further violations. So this is a significant change in the way the code is enforced, because we used to be able to say it was only related to real estate. Any kind of speech that impacts a protected class, you're a potential violation of Article 10. Again, I don't think any Signature agent is out there participating in hate speech, but we live in a very, very divided nation politically, and those types of things could potentially be a violation of Article 10. So I'm going to give you the advice that I give everybody else. Don't post anything on social media they wouldn't want your mother, your religious leader, or a jury of your peers to read out loud.
So I have a question for you, because this is problematic for me. Like, I feel, well, I mean, not that I'm out there, spewing hate on social media, but the reason it's a problem for me is because I'm looking at it from the perspective of, this is my personal life. And I know that everybody who is watching is going to probably say, well, when do I get to act? Where's my freedom of speech to say what I want? And so does it have to be my personal page or my business page, or it doesn't matter? Because of the fact that I am now a realtor member, I'm going to have to abide by this for Article 10 if it's not related to somebody in real estate or not related to real estate. I think that's where I need you to just clarify this a little bit better for me.
All right, so let's break this down, because there's a couple misconceptions in your statement. Number one, concept of freedom of speech. The First Amendment to the Constitution only applies to the federal government and limited opportunities to the state. So you do not have a First Amendment right of free speech on Facebook. You don't. They can monitor your speech. NAR can monitor your speech. It's a misconception that you can say whatever you want to on the internet and not have repercussions. You can. The Supreme Court, even in situations where they've determined it's valid free speech, there's a fundamental case out of the 60s where a guy ran into a movie theater and started screaming, "Fire, fire, fire," and there was no fire, and he thought it was really funny, and a lot of people ended up getting hurt. And he tried to argue that that speech was protected, and the Supreme Court said no. So the short answer is you really don't have a First Amendment right to free speech when it comes to private actors, because your remedy, if you don't want to comply with Article 10 as a real estate professional, is to leave NAR. You have an option. You can quit. And that's the way the court's going to look at this. Regarding personal versus private, we'll talk about the real estate division and advertisement in a minute, but the division's position is any time that there's a solicitation of real estate. So if you're on your personal Facebook page and a friend from high school says, so tired of our cold Illinois winters, can't wait to move to Vegas, Vonda, please help me find a house. Guess what? Real estate division doesn't care that's your personal page. You better have your broker license and your signature real estate information on there, because their position is you don't have a personal page. And the way NAR is writing this is it is regardless of venue. If you make these kinds of statements, it's a violation of Article 10. So it's not that I think that your agents are committing this. It's a very dramatic change in enforcement. We used to say, look, if you got on social media and you said that Dave Sanders is a jerk because he's a fan of the 2020 World Series LA Dodgers, that's not a violation of the Realtor Code of Ethics because it has nothing to do with the real estate transaction. But this transition in Article 10, if you're making hate speech, if you're involved in epitaphs, if you're making harassing speech against anyone who's a protected class, and we all know the protected classes are pretty wide under the code, that's a potential violation of the Code of Ethics.
But you are an attorney, and attorneys are not protected classes.
That is correct. My law degree does not protect me. So
all right. So let's talk about advertising, because you hit on it a little bit during our discussion of Article 10. So advertising issues, and then let's get into some of the things that you've heard through the Nevada Real Estate Division.
All right, so the division is actually stepping up their enforcement of the advertising rules. The division, in their last hearings a few weeks ago, they finalized a lot of those advertising rules that we've been waiting for. So if you haven't had a chance to look at them, I'm not sure if they're published just yet. The division is a little bit slower than normal because everyone is working from home. All the AGs, everybody is remote working, so it just takes a little bit longer. But they did finalize a lot of those rules that we've been waiting for since, I think, 2018. So it's pretty important to take a quick look at the advertising rules, particularly because, again, they do have, from what I understand, employees that their entire job is to search Facebook. And private Facebook pages, deleting the post doesn't really solve it if somebody took a screenshot. So get in the habit of all of your real estate, anything real estate related, make sure that you've got that license number, you've got the signature name on there, all those fun things, because I'd hoped that after a while they would kind of slow down their enforcement of this, because it was just kind of getting everyone in the habit of including their license number and their name and their brokerage. But it doesn't seem that they are slowing down on that anytime soon. So if it's the end of the year, it's a great opportunity. You're probably thinking about how you're doing your marketing for 2021. It's probably a great idea to make sure that you're in compliance with this, because yes, it's an administrative fine, but
they start adding up. Yeah, it's $500 for an administrative fine for every single violation, right? So if you have 5 people who've seen it and 5 people feel like it's a violation and all 5 of them turn you in, that's $2,500. Look at that math. That was quick. So the other thing is, I do want to mention is that I have the copy of the proposed language for NAC 645. So I'll go ahead and post it in the thread. I also want to make sure that it's really clear that when you say make sure you have your signature stuff on there, what he means is Signature Real Estate Group's logo or brokerage name needs to be in prominence So it's got to be bigger than your name or your team name, or it has to be at least the same, and it has to be on top versus on the bottom. So prominence is kind of the key word when it comes to advertising, and not to forget that. I know I teach a class on it. I know that we've talked about it several times during sales meetings. I know you're also trying to talk, so I'm going to give you a minute. Go ahead.
I was also going to say, make sure that you use the formal name of Signature Real Estate Group. You can't use initials. You can't just use Signature. You can't do anything like that. It's got to be the full name. If you did just Signature, they will ding you for the full fine.
Yep, because our name is not Signature. We're not hashtag Signature Real Estate Group. We are Signature space Real Estate space Estate space Group. Those spaces actually mean spaces. They're not the word space. Anyways.
I also don't know if the division will take hashtag Signature Real Estate Group. I don't know if I would rely on that if I were you.
Yeah, so we actually had Jan Hawley in the office several years ago to talk about it. And of course, that was years ago. So that could have changed. He said, look, am I going to ding you for the hashtag? Probably not. But here's the thing. You don't work for hashtag Signature Real Estate Group. You work for Signature Real Estate Group. So that's the way that it should be. Now, the name of the brokerage or the logo has to be in prominence. Remember that. Your now is also a requirement as of 2019's legislative update that your license number is on all your advertising. That does not need to be in prominence. It can be a click away, meaning somewhere on your page. And that should suffice according to the real estate division. And in case you guys forget, we have done all of our sales meetings. And I did have somebody, a compliance officer from the Nevada Real Estate Division, on one of those sales meetings. It is on our YouTube channel, so you can always reference back to those. Don't forget to subscribe to our YouTube channel, Signature Real Estate Group, in order to get access to all of that. Yes, I did shameless plug our YouTube channel. Okay, so advertising issues, we talked about that a little bit. Now here's the fun stuff. So those are your top 5 things. We put it in writing: mediation, the buyer broker agreement, Article 10, and advertising. Those are the top 5 things of 2020 that seem to sort of come back. And people think that it's more and more, that it does change a little bit, but they keep coming back as things change in that aspect. And just to back up for a second on the advertising issue, Dave, let's not forget that there might be people at the real estate division that their full-time job is to check social media. But you know who else is reporting realtors? Other realtors. Yeah. And so I've never gotten a complaint from an RED on TikTok or Instagram or whatnot, but it doesn't mean that there's not going to be a complaint. If you're doing something wrong on any of those other social media sites, your fellow realtors or licensees may turn you in. So be aware of that as well. Now, go ahead.
As I said, the platform doesn't really matter. I mean, when we had this conversation, when they first started instituting this rule, we were talking primarily about Facebook, but now I'm fairly certain that Instagram is a place that they like to look for as well. So basically, I just asked my teenagers, what's the cool website and the platform? And then, the division will get there in 3 or 4 years.
Perfect. So I think there was another one. I can't remember what it is. I keep asking Shelly every time because she subscribes to it or asked about it. But anyways, Hinged, I think. No, is that a dating site? Never mind. So let's go to the Nevada Real Estate Division's update. There was hearings for 3 days earlier this month. And I, listened in for some of it. And quite honestly, holy moly, I've been to the actual hearings, and I feel like since they've gone online where you can just hear them, they've become more aggressive. The Attorney General has been way more aggressive in the way that they're handling their cases and how they're asking questions, and it was scary. I mean, at that point, if you're sitting in front of the commission, like, just, sorry, I apologize, what's my fine? Like, stop fighting it.
Well, you're right. So the unfortunate truth is that the real estate division is not necessarily, there are other Nevada administrative entities like the Nevada Contractors Board, where they have an administrative law judge and an actual judge who rules on these decisions. Here you have 5 panels of practitioners, which has its pros and cons. The pros is they're familiar with the real estate industry, they know about it. The con is they're not judges, and they're not trained to have that necessarily impartiality, those kinds of things. And so, I unfortunately am telling clients at this point, look, if you get into a situation with the real estate division and they're investigating you, the first thing you do is you immediately cooperate, because they are slapping fines on, failure to produce documents in a timely fashion, turning that into an additional violation of NAC, which the fines can go up to $10,000 for just not producing the documents in a timely fashion. So again, hence earlier today when we were talking about your SkySlope system, and I'm begging you to put everything in quickly, it's not only so you can get paid, it's so that if the division comes a calling, you're not going to, get in trouble because you didn't produce all the necessary documents. So that's the first thing. The second thing is they are getting far more aggressive. I would tell you that if you get a situation and they give you an offer, it's definitely in your best interest to speak to an attorney, at least initially, to see if you can negotiate something quickly. You sat there, Vandana, you saw that not only did all of these settled resolutions involve an attorney on the other side who had actively advocated on behalf of the realtor to make sure, like if you come to me and you're getting a significant fine from the real estate division, my number one goal is to make sure you don't lose your license. Fines are one thing, but the ability to feed your family is something completely different. So let's make sure we keep that under control. I
do want to mention really quickly, if you don't mind, on the files over in SkySlope. When you're turning in your files, I mean, our office is getting a little bit more demanding of some of the documents that we're in need of, right? And where initials need to go, where signatures need to go. I mean, we're constantly reminding agents the duties owed must be signed first. I mean, if you are in front of the real estate division for any of these types of things and these items are out of line, or you haven't turned them in, or they're asking for more documentation and we don't have them in SkySlope because you didn't turn them in. For instance, our most latest version of, hey, we're going to need this from you moving forward, is on the request for repairs, when agents just write in the following items to be repaired: number 7 from inspection report, number 6 from inspection report, number 10 from inspection. Well, I don't know what those reference. And so we're going to need a copy of the inspection report, right? And so that's been one of the newest things that I think we've been really asking for lately, because I had an issue with a file that the Nevada Real Estate Division asked us for. And they said, we need the full documents, all the file, the entire paperwork for this particular transaction. And I turned it in. They said, well, what are you referencing here? And I'm like, I don't know. I got to go look it up. And sure enough, I went on to SkySlope and the inspection reports weren't turned in. I turn in everything, right? Sometimes almost I feel like too much, but I know I do my job right. And there isn't anything on there that I'm worried about. And if you are worried about something because you believe you screwed it up, talk to one of the brokers, you guys. I mean, we're here to help you, right? So that was my little side.
And cooperating it from the initial, because there is a scenario, it is a violation of NAC 645 for you not to produce the entire file. That's considered an impeding the active investigation of the division. That's a separate violation that you can get with another $10,000 fine. So if they're looking at it because they're worried that you didn't initial the duties owed, and then they see that you didn't include 7 or 8 different documents, your fine that could have potentially been $500-600 is now potentially $20,000 to $30,000.
Yep. Like I said, I don't get into real estate to pay the real estate division, right? Nobody wants to do that. And then the other thing, while I was listening, still, I mean, property management is a big deal still, where people are getting fined for, things that they're doing in property management without a permit. Yeah,
that's an active situation. I mean, at the end of the day is if you get a complaint from the real estate division where they're asking for a file and you're asked to go down in front of the commissioners, you have to realize that this is a trial in front of a judge, the 5 of them, and
with an attorney general on the other side. Yeah,
2 of them. They have two.
Jesus.
They have one for the panel and one who's a career prosecutor whose job is to prosecute people like you. And so, if you get in that situation, certainly hire someone. But I would tell you, it's certainly better, if you're going to go down there and you're going to do the crapshoot and you're going to try to appeal to the commissioners, all bets are off. No lawyer can guarantee your success, and and the amount of sanctions that the AG's office you've negotiated with, say it's a $1,000 fine and 6 hours of CE, and you decide, no, all I need to do is have the commissioner tell my story and I'll be vindicated. They're not bound by that plea offer. They could go in and ask for suspension, revocation, the whole 9. It's an entire crapshoot if you go before the hearing. So unfortunately, I would tell you it's not worth fighting City Hall with the division. It's certainly better to, one, ensure that you're not doing things that would warrant that, but two, making sure that you're actually getting the information that you need, providing, cooperating with them, and, taking it incredibly seriously because they have two full-time attorney generals, so this is their job on top of the commissioners. And if you think that the real estate commissioners are going to believe you over the career prosecutors and the investigators that they work with every day, that's a little naive.
Yeah. Anything else you want to talk about from the real estate division? Well,
yes,
because I know you heard the whole thing.
Yes. The other thing that they are doing is they are including the cost of investigation as a fine against the real estate licensee. So it's not just the $2,000 to $3,000 in fines. They're going to charge you whatever it costs them for Jan Holly to do his investigation, whatever it costs the AGs to do their work. So the longer and the more you fight, the increase of that cost of investigation can go up dramatically from a few $100, as I'm sure Vandana, you heard when people were settling to several $1,000s. They are, though, still giving you the opportunity to make payments over time. So that's good. But they have recently, and I say in the last year, they started increasing the cost of tagging you with the cost of investigation, which is allowable under state law. And
if you miss a payment, by the way, right, then they tack on additional fines for that. And
it depends. They could also go back and say that there was no settlement agreement and go back and do the hearing and demand full sanctions. So do not miss a payment.
Yeah. Holy moly. All right. Before I know we've got two more topics that I really want to touch on. One of them being the DOJ case and sort of what's going on with that and an update on that, if you don't mind, because the last time you were doing a legal update, we talked about what had occurred, but we never really dove deep into what's happened since.
So the short answer is we still don't know because of the way the antitrust cases work. This case, the Department of Justice came in, they fought a lawsuit against NAR alleging that certain practices under the MLS were anti-competitive. And those were prohibiting MLSs from disclosing the amount of commission that the buyer has. So the buyer commission that's being offered by the seller is now going to be something that's going to go out in the IDX feed eventually to everyone. So you can search it on Zillow, you can search it on Realtor.com, you can search it on individual real estate agents' websites. The second one is allowing buyer's agents to say that their services are free to the buyer. The third was they have to allow a searchable field in the MLS to allow buyer's agents to search properties by the amount of commission that's being offered. Now, I know some of these may not apply in our local market, but this is a nationwide settlement. And then the last one is you can't limit lockbox access to only LVR members. So what happens with an antitrust case is they've proposed this settlement. By federal law, they have to seek public commentary for 60 days, which is going to expire in January. And then we'll have the finalized settlement agreement that'll go before the judge, and that'll take 30 to 45 days. And then after that, NAR is going to be issuing out their rulings and regulations. So we're looking at probably another 90 to 120 days before we know anything specifically. We do know that the commission amounts will be out there. We do know that the buyer's agents will no longer be able to say that their services are quote unquote free. What you will be able to say, we don't know. So again, buyer brokerage agreement is really going to be the way that you can address that, no matter what that final language is going to be. And it will be interesting to see what happens with access to the lockboxes, but we don't know anything right now. We'll know more in the next 30 to 45 days. But if you are primarily an agent that makes most of your money telling buyers that they don't have to pay for your services, you may want to start considering a different type of marketing. Your skill set, your knowledge with the neighborhood, your negotiation skills. And you may want to start looking at that because I don't know what you will and will not be able to say. I know that you will not be able to say, my services are free, you will not have to pay for them. There might be some variations there, but until we have the final rules, I couldn't tell you what to do. So it's really just an idea of, we don't know what's coming, but get used to using a buyer brokerage agreement, because if, for example, after these rules come down and the buyer wants to purchase a home at 1% and your buyer brokerage agreement has you at 2% or whatever number that is, you're going to have a conversation with the buyer that when you're submitting the offer, you've entered into a contract with me to pay this amount. Now, we can potentially try to get the seller to pay us more, but if they don't, you're going to be on the hook. So that, I think, is going to be really interesting to see what's going to happen. And we'll know more in the first quarter, but getting used to that scenario is going to be very interesting.
And you may not be prepared for this answer, so I'll just put it out there. Is public comment right now is what's happening? What can we do as a licensee to
NAR
make a public comment?
NAR is producing their own public comments. You got to go through the Federal Reserve, the Federal Registry. It's not like you go to Yelp and you type in something. It's a little more formal than that. I know your trade organization is putting language together. I know that LVR and NVR is on top of this. The interesting thing about this case is that the National Association of Realtors agreed to these terms in principle before the lawsuit was made public. So they've been in negotiations with the Department of Justice. So I have absolute belief in Katie Johnson and her team in Chicago. They're probably very familiar with what this language is going to be, barring any kind of crazy language in the Federal Registry. They probably already got a plan in place and will have an idea of where this is going. They just can't tell you what it is until the judge finalizes everything.
Okay, and we're going to have you back here. So once there is an update, you'll be able to tell us. Obviously, keep listening in, and your brokers will tell you on a sales meeting, so on and so forth. Okay, so there's that. COVID addendums. There's like 6 of them now. Okay.
Yes, there are.
So, well, there's 5 of them, and so I want to run through them. This was actually by special request from an agent in our office. Because there are so many of the addendums, the question is, when do I use it? Why do I use it? What's the purpose of using them? So if you don't mind, let's just go through them one at a time, if that's okay. Sure. The first one I want to talk about is the coronavirus addendum and amendment. Now, that is the one that we created, you and I created as part of something that we needed right when COVID hit. Like that was, boom, that happened. And it was also prior to getting the one from the association, because the association has another COVID addendum / amendment. So there are 2 of them. Let's talk about the one that we did first and submitted to our agents. So let's go for that one.
So the first form, the one that we created, is the one I would recommend that you use if you're a buyer's agent and you're concerned that the buyer may have difficulty getting financing or anything related to COVID-19 illness, et cetera. There is not what's known as a force majeure or act of God provision in the residential purchase agreement. And the force majeure act of God provision is a situation that says if there's a pandemic like COVID that impacts the party's ability to execute the contract, we're going to release everyone without any kind of penalties. Buyer gets their earnest money back. Seller is allowed to move on and attempt to resell. There isn't anything like that. There are sellers and buyers that, early in March, April, May, were trying to make the argument that they were either way entitled to the funds because of COVID. You're going to be relying on a judge to decide that, and that's not necessarily a bad thing. It's just there's a lot of unknowns when it comes to the courthouse and it comes to judges and filing these types of things. So if you're a buyer's agent, I would definitely recommend you use the first one, the coronavirus addendum amendment. It allows the parties to, end the transaction if there's complications related to COVID, either exposure and there's health issues and they're hospitalized, they lose their job, they're able to secure financing. I know that in the beginning of March, there was a significant problem with foreign investors securing loans because they were just not issuing loans to foreigners for any types of purchases in the United States. So that's the first one, and that's where you would use it. You would include it as a part of your offer on the RPA as a part of practice right now because of the continuing COVID outbreak.
And then there's one from the association that came out, and that was, and I believe in the packet that I sent you, that's number 6. And I'm sorry to jump from one to another, but it was the LVR Realtors. It's got the logo on top, and it says Coronavirus Addendum and Amendment. Now that is also in regards, it has a force majeure clause, in it. It talks about the amendment, but my understanding of that document is that it was copied from California. And so there are things in there that don't apply to us. Is that correct?
Correct. The California Association of Realtors auto-populates dates in all of their contracts. So they will say, the due diligence period will end within 14 days of execution or blank, and gives you an opportunity to put a number in. So you have that here, which you as Nevada and Las Vegas realtors, you're not used to filling out. And so your compliance people are going to say you've got a blank here, and it's 30 days may or may not be the situation where if there's a problem with COVID, you want to kick it out that automatic time. So that's the biggest difference. It also has a little bit of different way the form is filled out. So I don't recommend using it, because when we were looking for COVID forms, we took COVID disclosure forms from across the country, and we took the best parts of every single one of them. We went back and looked at the RPA. We made sure to make it look as familiar as all of the other addendums that you use. And it's not based on another state's form without at least doing an analysis to verify that it works with the forms that you use. If you're a seller's agent and you get this form from the realtors, the first thing you'll really want to check is number 1 and number 2 and number 3, because they're not mutually exclusive. There's that 30-day window in number 1. You can address number 2 and number 3. So I would take a look at that and make sure that you're having that conversation with the seller. It's not a requirement, despite what everyone thinks, to use the association's forms. You don't have to. If Signature has a better form, for example, you're completely allowed to use that, as long as the parties agree.
Right. And so the other thing about that is that you can't actually just go write forms. I want to clear this up really quickly before. So you as a licensee cannot go write a form and start using it, right? The reason that this form is okay is because we had our attorney vet it, write it. And it is, quite honestly, Dave, you wrote all the other forms at the association, so why not write the forms for us? They all sound the same. They look the same. They feel the same. They have the same, amount of syllables, because that's how you get paid. All of that stuff is all the same for the most part. So why not utilize it with you? And so just to clear up, you as a licensee in our office are not allowed to write forms and start using them. They have to be approved by the broker. Our E&O insurance will not cover a random form that you create. If our attorney creates it, we are in a better position. Yes,
you've hit all the big issues. The other issue is that as a licensee, you're not familiar with writing legal forms. And while you think you may be anticipating every scenario, that's not your education background, that's not your experience level. And there is case law
outside of the scope of your license.
And even better, there's case law that indicates that errors in drafting are interpreted against the drafter. So if you write your super cool addendum and you think you've covered everything, and it creates a whole lot of problems, it's not the other side, it's not the other agent, it is you, and it's not even your client. So you're opening yourself up to a significant amount of liability in that scenario. It'd be much better to reach out to your brokers, find out the scenario, and then if they think it's something that deserves or it requires additional verbiage, they can reach out to an attorney and make sure that we get you the language that you need.
Perfect. All right. The second form is the COVID-19 disclosure for property access. Now that form, I want to just clarify that, again, that was a form that you had created. It was to allow access to property, and to say, I think from a seller's perspective, it was more for their protection. If somebody comes in and gets sick, it's for our protection as a licensee. If somebody comes in and the seller gets sick, hey, it's not our fault. We're trying to sell your house. It is, you agree that you haven't been exposed in the last 14 days. You're not experiencing any cold or flu-like symptoms. You haven't been diagnosed with COVID. You haven't had a test in the last 14 days or have a test that's pending, things like that, right, is what it's assuring. And it is a CYA for us as licensees, as well as a CYA for the clients, so that they're not suing each other. I mean, let's be real, they can sue each other for just about anything, but yeah.
Yes, it's also to ensure compliance with the governor's special orders. I mean, one of the things that real estate has been very blessed with through this terrible tragedy is you still have been able to conduct business. You've been determined to be an essential, necessary service.
Thank God.
You know, there was a time that you weren't allowed to do walkthroughs. You weren't allowed to do showings. You weren't allowed to do open houses, and those were all restricted because the governor said, okay, we'll let you do this, but you're going to come and comply with CDC guidelines. or certain things you have to do. You have to verify that the people coming through the property have not been diagnosed with COVID, and that's what this form does. I mean, not only does it protect you from liability, but it continues to allow you to do business because, we've seen, not so much in Nevada just yet, but if you're looking at Southern California, or if you're looking at New Mexico, I mean, I'm a college football fan. The Albuquerque, New Mexico college football bowl over the weekend was not allowed to occur in New Mexico because of COVID. So they had to play it in Texas. And I laughed the entire time. So my point is that you have the ability to continue to do business because you use these types of forms. Do yourself a favor and make sure that you're using these, to not giving the governor any reason to decide that real estate is no longer essential, and then you're no longer able to feed your family.
Perfect. And then the third form, which is actually a form that we have at Signature. It's on our Signature website for the all things Signature. What is it called? It's the Signature resources page. And it is the COVID-19 safety acknowledgement. It's a liability waiver and release of claims. Now, we had planned to do several events for Thanksgiving. And so this form was created for that purpose. And it's a 2-pager. We're obviously not using it. It's more for, hey, agents, you are going to be participating in an event that we are holding as a company, and you agree to certain things, right? Again, it's something that, we created for events at Signature. So it's got nothing to do with transactions. I wouldn't even look at that unless we as a company ask you for it.
Eventually there'll be a time where you'll be allowed to open up and do, small groups, those kinds of things. You'll need to verify this kind of thing. And it's really just designed to protect everyone and allow you to continue to do business.
And then the last form that I want to talk about, which is number 5 in the packet that I sent you, is the coronavirus notice. Now that was created, my understanding, and from what I remember, through the CDC. It was in conjunction with the CDC, the Nevada Real Estate, not Real Estate Division, Nevada Realtors. So it was a combination. This was not a form that you created. It was just something that we've had. The purpose of this form, I'm going to let you go ahead and talk because it's been a while. Go ahead. Sure.
It's not a bad form to use. I would tell you that it's the one so this is a situation where, if I was having an open house and you're having people come through, not only would I have them do number 2, I would have them do number 5 as well, because 5 has language about indemnification. Now, I'm really worried about lawsuits for someone walking through a house and contracting COVID. Not necessarily. It's extremely difficult for people to prove where they got it from. But at the same time, I would probably consider this, and if it may be time for us to take a look at the disclosure for property access and include some indemnification and waiver language, now that we know, due to the emergency session of the legislature, that if businesses are complying with the CDC guidelines in Nevada, there is indemnification for them, meaning that if you're complying with the requirements to have an open house, there's indemnification from being sued by somebody who walks through and claims they got COVID at your open house. So we may want to take a look at some of these forms and update them in light of some of the governor's transitions. But right now, you've got a lot of documentation that's going to protect you. Most of them, again, are not necessarily transactional. It's really just number 1, not number 6. And then the rest of them are dealing with people who want access to the property and ensuring that they're not in violation of the COVID CDC restrictions and guidelines.
Perfect. So I think we've got everything covered. Was there anything I missed that you absolutely want to hit on for a legal update, Dave?
No, I think we've hit the major issues. I mean, it's been a tough, trying year with everything that's been going on. Regardless of COVID, we would be talking about making sure you're writing everything down. With COVID, it certainly becomes even more important to make sure you do that. The division is gone back. They're continuing to have hearings by essentially Zoom calls for the foreseeable future. The downside with that is, it used to be that the division would have 3 hearings in the South and 1 hearing in the North. And now, I don't know if you noticed the December hearing, the really, really long hearing on day 2 of the trial, that one was actually a
oh my God,
case out of,
yes.
It was a case out of the North. So it's not like I can tell you, hey, there's only 3 times that if you got a hearing before the real estate division, if it's September is the time they go to the North, which they historically did. They're not doing that anymore. They're having these like this, and it's going to be, let's be honest, at least probably through their first, their first hearing in the first quarter, maybe even the second quarter. So I don't see that ending anytime soon.
Perfect. So with that, I definitely want to end, but I thought it'd be really funny to do a legal type of joke type of thing. So I'm going to read this. Okay. So it's Merry Christmas from your lawyer. Have you seen this before? I wish you, but in no way guarantee a reasonably Merry Christmas and or festive period, including but not limited to a reasonably happy 12 months from the date hereof. And so I thought that was kind of something that we should end with.
I have to confess that you've just described my holiday decorations when I was Joe Villar's attorney at my office for 2.5 years in a row. I could never compete with Robin and all the Winnie the Pooh stuff, so that's what I went with.
Right. Perfect. So with that, you guys, thanks so much for listening in. Do not forget, your brokers are here to help you. Your brokers are here to assist you through anything that comes about, whether it's now until the end of the year or the beginning of 2021. So happy New Year. Happy ending to a decade, because we are at the end of 2020. Your last Tuesday of the year, right? I'm trying to think. What else are there the last of? That's it. That's all I got. So happy New Year. Thank you so much.
Too.
Yeah. Thanks so much for being with us today, David. We appreciate you.